Hello everyone, hope you all are doing well. So today's topic is Indian Evidence Act 1872. A very quick revision. So let's start with part 1, that is relevancy of facts, in which chapter 1 preliminary. So in preliminary we will discuss 4 sections. So section number 1, short title, extent and commencement. Section 2, repealed. Section 3, interpretation clause, in which there are definitions, that is court, fact, relevant, fact in issue, document, evidence, proved, disproved, not proved, India, and etc. And section 4, may presume, shall presume, conclusive proof. Chapter 2, of the relevancy of facts. Section 5, evidence may be given of facts in issue and relevant facts. Section 6, relevancy of facts forming part of same transaction. 7, facts which are the occasion, cause or effect of facts in issue. 8, motive, preparation and previous or subsequent conduct. 9, facts necessary to explain or introduce relevant facts. 10, things said or done by conspirator in reference to common design. 11, when facts not otherwise relevant become relevant. 12, in suit for damage, facts tending to enable court to determine amount are relevant. 13, facts relevant when right or custom is in question. 14, facts showing existence of state of mind or of body or bodily feeling. Section 15, facts bearing on question whether act was accidental or intentional. 16, existence of course of business when relevant. So admission part. Section 17, admission defined. 18, admission by party to proceeding or his agent by suitor in representative character. 19, admissions by person whose position must be proved as against party to suit. 20, admissions by persons expressly referred to by party to suit. 21, proof of admissions against persons making them and by or on their behalf. 22, when oral admission as to contents of documents are relevant. 22A, when oral admission as to contents of electronic records are relevant. 23, admissions in civil cases when relevant. 24, confession caused by inducement, threat or promise when irrelevant in criminal proceeding. 25, confession to police officer not to be proved. 26, confession by accused while in custody of police not to be proved against him. 27, how much of information received from accused may be proved. 28, confession made after removal of impression caused by inducement, threat or promise relevant. 29, confession otherwise relevant not to become irrelevant because of promise of secrecy, etc. 30, consideration of proved confession affecting person making it and other jointly under trial for same offense. 31, admissions not conclusive proof but may stop. So now statements by persons who cannot be called as witness. Section 32, cases in which statement of relevant fact by person who is dead or cannot be found, etc., is relevant. 33. Relevancy of certain evidence for proving in subsequent proceeding the truth of fact therein stated. Statements made under special circumstances. Section 34. Entries in books of account when relevant. 35. Relevancy of entry in public record made in performance of duty. 36. Relevancy of statement in maps, charts and plans. 37. Relevancy of statement as to fact of public nature contained in certain acts or notifications. 38. Relevancy of statements as to any law contained in law books. Now, how much of the statement is to be proved? Section 39. What evidence to be given when statement form part of a conversation, document, electronic record, book or series of letters or papers. Judgments of court of justice when relevant. So section 40. Previous judgments relevant to bar a second suit or trial. 41. Relevancy of certain judgments in probate, etc. jurisdiction. 42. Relevancy and effect of judgments, order or decrees other than those mentioned in section 41. 43. Judgments, etc. other than those mentioned in section 40 to 42 when relevant. Section 44. Fraud or collusion in obtaining judgment or incompetency of court may be proved. Now, opinions of third person when relevant. So, section 45. Opinions of experts. 45A. Opinion of examiner of electronic evidence. 46. Facts bearing upon opinions of experts. 47. Opinion as to handwriting when relevant. 47A. Opinion as to digital signature when relevant. 48. Opinion as to existence of right or custom when relevant. 49. Opinions as to uses, tenants, etc. when relevant. Section 50. Opinion on relationship when relevant. 51. Grounds of opinion when relevant. Now, character when relevant. Section 52. In civil cases, character to prove conduct imputed irrelevant. 53. In criminal cases, previous good character relevant. 53A. Evidence of character or previous sexual experience not relevant in certain cases. 54. Previous bad character not relevant except in reply. 55. Character as affecting damage. Now, part 2, that is on proof. So, chapter number 3, facts which need not to be proved. So, section 56, fact judicially noticeable need not to be proved. 57. Facts of which court must take judicial notice. 58. Facts admitted need not to be proved. Chapter 4 of oral evidence. Section 59. Proof of fact by oral evidence. 60. Oral evidence must be direct. Chapter 5 of documentary evidence. Section 61. Proof of contents of documents. 62. Primary evidence. 63. Secondary evidence. 64. Proof of documents by primary evidence. 65. Cases in which secondary evidence relating to documents may be given. 65A. Special provisions as to evidence relating to electronic record. 65B. Admissibility of electronic records. 66. Rules as to notice to produce. 67. Proof of signature and handwriting of person alleged to have signed or written document produced. 67A. Proof as to digital signature. 68. Proof of execution of document required by law to be attested. 69. Proof where no attesting witness found. 70. Admission of execution by party to attested document. 71. Proof when attesting witness denies and the execution. 72. Proof of document not required by law to be attested. 73. Comparison of signature, writing or seal with other admitted or proved. 73A. Proof as to verification of digital signature. Now public document. Section 74. Public documents. 75. Private documents. 76. Certified copy of public documents. 77. Proof of document by production of certified copies. 78. Proof of other official documents. Now presumption as to document. Section 79. Presumption as to genuineness of certified copies. 80. Presumption as to documents produced as record of evidence. 81. Presumption as to gazettes, newspapers, private acts of parliament and other documents. 81A. Presumption as to gazettes in electronic forms. 82. Presumption as to document admissible in England without proof of seal or signature. 83. Presumption as to maps or plans made by authority of government. 84. Presumption as to collection of law and reports of decisions. 85. Presumption as to power of attorney. 85A. Presumption as to electronic agreements. 85B. Presumption as to electronic records and digital signatures. 85C. Presumption as to digital signature certificates. 86. Presumption as to certified copy of foreign judicial record. 87. Presumption as to books, map and charts. 88. Presumption as to telegraphic messages. 88A. Presumption as to electronic messages. 89. Presumption as to due execution, etc. of documents not produced. 90. Presumption as to documents 30 years old. 90A. Presumption as to electronic records 5 years old. Now chapter 6 of the exclusion of oral by documentary evidence. So section 91. Evidence of term of contract, grants and other disposition of property reduced to form of document. 92. Execution of evidence of oral agreement. 93. Exclusion of evidence to explain or amend ambiguous document. 94. Exclusion of evidence against application of document to existing facts. 95. Evidence as to document and meaning in reference to existing facts. 96. Evidence as to application of language which can apply to one only of several persons. 97. Evidence as to application of language to one of two sets of facts to neither of which the whole correctly applies. 98. Evidence as to meaning of illegible characters, etc. 99. Who may give evidence of agreement varying term of document. 100. Saving of provisions of Indian Succession Act relating to bills. Now part 3. Production and effect of evidence. So chapter 7 of the burden of proof. 101. Burden of proof. 102. On whom burden of proof lies. 103. Burden of proof as to particular fact. 104. Burden of proving fact to be proved to make evidence admissible. 105. Burden of proving that case of accused comes within exceptions. 106. Burden of proving fact especially within knowledge. 107. Burden of proving death of person known to have been alive within 30 years. 108. Burden of proving that person is alive who has not been heard of for 7 years. 109. Burden of proof as to relationship in the case of partners, landlord and tenant, or principal and agent. 110. Burden of proof as to ownership. 111. Proof of good faith in transaction where one party is in relation of active confidence. 111A. Presumption as to certain offences. 112. Birth during marriage, conclusive proof of legitimacy. 113. Proof of cession of territory. 113A. Presumption as to the abatement of side by a married woman. 113B. Presumption as to dowry death. 114. Court may presume existence of certain facts. 114A. Presumption as to absence of consent in certain prosecution for rape. So, Chapter 8, Estoppel. Section 115, Estoppel. 116. Estoppel of tenant and of licensee of person in possession. 117. Estoppel of acceptor of bill of exchange, bailee or licensee. Chapter 9 of witnesses. Section 118. Who may testify? 119. Witness unable to communicate verbally. 120. Parties to civil suit and their wives or husbands, husband or wife of person under criminal trial. 121. Judge and magistrates. 122. Communications during marriage. 123. Evidence as to affairs of state. 124. Official communications. 125. Information as to commission of offense. 126. Professional communications. 127. Section 126 to apply to interpreter, etc. 128. Privilege not waived by voluntary evidence. 129. Confidential communication with legal advisory. 130. Production of title deeds of witness not a party. 131. Production of documents or electronic records which another person having possession could refuse to produce. 132. Witness not excused from answering on ground that answer will criminate. 133. A complaints. 134. Number of witnesses. Chapter 10 of the examination of witness. So, section 135. Order of production and examination of witness. 136. Judge to decide as to admissibility of evidence. 137. Examination in chief. 138. Order of examinations. 139. Cross examination of person called to produce a document. 140. Witness to character. 141. Leading questions. 142. When they must not be asked. 143. When they may be asked. 144. Evidence as to matters in writing. 145. Cross examination as to provides previous statement in writing. 146. Question lawful in cross-examination. 147. When witness to be compelled to answer. 148. Court to decide when questions shall be asked and when witness compelled to answer. 149. Question not to be asked without reasonable grounds. 150. Procedure of court in case of question being asked without reasonable ground. 151. Indecent and scandalous questions. 152. Question intended to insult or annoy. 153. Exclusion of evidence to contradict answer of questions testing veracity. 154. Questions by party to his own witness. 155. Impeaching credit of witness. 156. Questions tending to corroborate evidence of relevant fact admissible. 157. Former statements of witness may be proved to corroborate later testimony as to same fact. 158. What matters may be proved in connection with proved statement relevant under section 32 and 33. 159. Refreshing memory. When witness may use copy of document to refresh memory. 160. Testimony to facts stated in document mentioned in section 159. 161. Right of adverse party as to writing used to refresh memory. 162. Production of document or translation of document. 163. Giving as evidence of document called for and produced on notice. 164. Using as evidence of document production of which was refused on notice. 165. Judge's power to put question or order production. 166. Power of jury or assessor to put questions. Chapter 11. Of improper admission and rejection of evidence. 167. Section 167. No new trial for improper admission or rejection of evidence. So this is the Indian Evidence Act, all section. So we have covered 167 and hope you all will remember it. Good luck.